Hello and welcome everyone to Kids for Ransom, the podcast where we expose the flaws, corruption, and systematic failures of the modern family court system.
We're just two everyday dads fighting for our kids and speaking out for parents across the country who are struggling to stay connected to their children.
In every episode, we'll dig into the real world scenarios, court documents, and personal stories that show us how the system is broken and how it's being used to hold our children hostage in legal battles that too often serve money and power, not families or justice.
We'll also break down the laws, policies, and court procedures that are being misused and or misunderstood, and we'll share the hard-earned lessons we've learned along the way.
Just to be clear, nothing we share should be taken as legal advice. We're not lawyers. We're parents, and we're here to inform, educate, bring awareness to the reality that too many families are facing.
If you'd like to follow our journey, hit that thumbs up and subscribe and hit that ping notification bell. Families are being broken in silence. It's time to pull back the curtain on family court and stand with parents and children being held for ransom.
Hey, Sam, what's going on? Got some
Well,
new
another one of
problems
those,
in the court system.
yeah, another one of those days in court that too many people deal with. It's one of those days where you feel like the judges are going to do whatever they want. The law doesn't matter, the truth doesn't matter, your arguments don't matter. Um, so yeah, today was one of those frustrating days.
I feel that.
Yeah, we've definitely all been through those, and just since we started doing this podcast, people have reached out and they're like, me, I'm having the same problems, and it's like they're all in different states. This isn't even
Right.
a particular state problem. This is every single state is conducting the family courts this way.
Yes, yes, absolutely. I'm learning more and more about it. I noticed that more and more podcasts are kind of like coming, or not even just a podcast, but like just more and more, people are speaking out. It's through, whether it's social media, we got podcasts that are opening up with people expressing. We even just recently heard of attorneys that were actually reporting this kind of stuff. There was a guy in Nevada who actually he was an attorney for years and he was getting stepped on by the courts here in California,
Yeah,
which, yeah, yeah. I mean,
I don't doubt it because
you
my
know,
local court has a trial rule that not only allows, but they specifically instruct you to not serve your trial documents ahead of time and show up with surprise evidence.
yeah,
And when I found that out, it's like I don't even think an attorney could protect themselves in a situation like that.
that's sick. Yeah, absolutely. I mean, that
It,
goes
it- it's
against
it's just ripe for abuse
that's all kinds of rules of breaking the rules of court right there, you
and
know,
just basic due process.
and due process. I
Kind of
mean,
a big one right there.
if people paid attention to the news, man, they see if they were to pay attention, they would see that title used a hell of a lot in not even just in family court. But this is the interesting thing, man. This country has just been completely turned upside down on the judicial system where due process doesn't even exist. Now, we won't go into those things, but I'm just saying, look at headlines, my friends, on in news stations. Due process is not happening, and that is one of the compass of our family courts. We need that, right?
If they were really strict about due process, that alone could really catapult the family courts in a positive direction. It could really have a positive impact on children's lives across this country. But they
Yeah,
don't want that. I think it's like these judges want this power. They want to be able to rule however they want. Today
yeah,
I had to basically tell my judge she wasn't following the law. And it's the last thing you want to do because these people have egos.
right, yeah,
You think she's going to rule in my favor after I tell her that?
right, right,
But what
right.
choice do I have when she's not following the law?
Kind of hard to stroke an ego that you like to stroke that ego. You're still like well, they're not getting it. They're going their own direction. You got to be able to put a halt to it. So, in the psychological way of going about it is like, hey, do I stroke their ego and such? Oh wow, Your Honor, that was, you're brilliant for coming up with that, but that's not what I put. That's not what I saw in the paper earlier. I don't know. Like,
Well, yeah,
what do we gotta do? What do we gotta do?
I've definitely heard that argument, right? If you get an opportunity, kind of stroke their ego a little bit, try to get them on your good side. But the
Yeah,
problem is they got to give you an opening for that,
yeah, yeah,
you
yeah.
know? And when their behavior seems to fall in line with this mindset, like they just want you to submit to them, they don't want you to challenge them.
Right, right,
And,
yeah, yeah,
I can sit back and wait and see what's going on here. But when you've been through this for years and your child's being taken away, your child's being hurt emotionally and psychologically, and they're just not seeing it,
yeah,
you know?
absolutely. Yeah, yeah,
Um, so today, man, what happened? It's a little background, with right when all this uh, court stuff started. At the beginning, I got 50-50 equal parenting time.
yeah,
And the following hearing after that, they issued joint legal custody. And that was while we were waiting for the restraining order trial. So we had to wait like 4.5 months. So I had equal parenting time, had joint legal custody. Um, and so we get to the trial. They decided that me expressing anger in another, removing myself, going into another room, expressing anger was domestic violence. They gave her a 1-year restraining order. Um, and they said in the order, Family Code 3044 now applies, being that they decided domestic abuse happened. And they reduced my parenting time down to 2 days, which I'm lucky to still have 2 days with a restraining order. A lot of parents in that situation get like 2 hours of supervised or 8 hours of supervised visitation. So I was very lucky when it comes to that.
yeah, yeah.
And that's all they changed. They said 3044 now applies. They reduced my parenting time, and that's it. Afterwards, my judge confirmed with me they didn't remove joint legal custody. The joint legal custody still stands, meaning that I have just as much say as the other parent when it comes to decisions regarding education, medical decisions, and so forth. Um, as we progressed through this case, it became clear that the other party was just making unilateral school decisions and medical decisions, would tell me that I can't take her to the doctor unless I notify her and she's allowed to be there, which with a protective order, that gets a little weird. It's like
Right,
she's pushing me out to where I'm not allowed to be there if she goes to the doctor.
right, right. Yeah,
And
experience
as
that.
the cases progressed here, and we went through this restraining order extension trial in October, opposing counsel has been continually not directly saying, but insinuating to judges as if the mom has sole legal custody
Mm,
when it was never removed. And so that made me start questioning at one point, like, wait a minute, do I not have legal custody? Even though my attorney told me right after that first trial, do I not have legal custody because the restraining order? Does it just magically disappear? So I did my research, and it does not just magically disappear. In fact, um,
mm,
there's a couple different family codes that would actually argue that's not how it works. Family Code 3087 says joint legal custody stays in effect until modified by a new order. Well, that makes sense, right? Because court orders shouldn't be insinuated. They should be very clear so that all parties can understand them and follow
yes.
them. Family Code 3022 requires due process before any custody order could be changed. So in this situation, at the beginning of 23, there was an order. They issued joint legal custody. And through every court order since then, they've never modified legal custody. So
Which should make that be the ultimate order that would be standing order in that
yeah,
time.
yeah,
Yeah,
yeah. If there's not been an order that has directly changed legal custody since then that last order that modified legal custody stands.
Well, good. Good.
And
I have a good story on that one. I
and
got a good story when you're
that's a
done.
common phrase. That's a common phrase we see at the end of these orders. I'm sure you see them in yours too, right?
Yeah.
Any orders not in conflict. What's the phrase? Any orders not in conflict basically remain in full force and effect. I think something along those lines. That's a common phrase they put at the end of these orders because sometimes they'll change just part of it.
Yeah.
So anything not conflicting with what they changed is still an order. It's still there.
Yeah.
And that's what we see here. At one point they issued joint legal custody and they've never changed joint legal custody. They've given a protective order. They've said 3044 applies and therefore parenting time must be reduced, but they never ordered to change custody. So so since I'm dealing with someone who is constantly, in fact, that misinterpretation of custody, I think, contributed pretty severely towards being denied overcoming Family Code 3044 in February. And so, I'm trying to chip away at some of these old misinterpretations or misapplication of law in regards to my case to try to get some momentum here and move in a positive direction in
Yeah.
regards to custody. So I filed this order to clarify legal custody. I was not looking to change it. I was only looking to clarify it.
Right. So you get like literally everything everything in transparent as to what was the actual orders.
Well, yeah, exactly, because I do my homework. I interpret it as reading the law, reading case law, reading family code. Given the situation, I have joint legal custody. Mom has joint legal custody. But
Yeah.
the other party is misinterpreting that in a different way. So that's why I filed this motion. And I specified this is for clarification, not to change it. And when you file a motion like that, they can't just add on new things and change it. The other party can't just say, "Oh, well, we'd like to request that it should be changed to mom having sole legal custody."
But during your motion.
Exactly. They would have to file their own motion, their own RFO, request that, and then serve it to me, give me proper notice and a chance to respond and make arguments.
Which is interesting because there's that one objection we all should remember to use is objection, Your Honor, relevance because this is my motion. And that's something that and that's just my problem because I forget a lot of the times when I'm in hearings on I get caught up in what the stupid context is when it's
Yeah,
more
yeah,
what's actually the legal procedure
yeah,
and that's as a pro se litigant we got to remember procedure. And I thought of another one, but we can talk about that here in a little bit. But I want to make sure I mention that procedure. We could make some easy mistakes on that. But I don't. What was your experience with that?
well, I know as far as the objections, the problem for me is that a lot of the time it really seems like they just don't want you to object.
I know they
They just want to hear it and they want to decide. They want the power. That's how I interpret it.
Well, yeah, I know. Though we have to do it. We have to do the objections. We have to
Yeah,
actually and make sure we get them right. My judge got pissed off at me by getting out of control with the objections
yeah,
because I
yeah.
wasn't using them, correctly. But
Uh-huh.
there's like certain ones hearings that I did. But that's huge. We have to remember relevance. Your hearing is here because of what you filed, and we have to stick to that by calling it out as objection relevance.
Yeah,
This is
yeah,
not a matter, and I've done that in my hearing, and that actually did kind of give a little bit of that wall that I needed to like shut her up, right?
yeah.
But that's a kind of a big one. Um, True. And actually thinking, but go ahead and finish. I'm sorry.
Oh no, you're fine. So I went in today. I had, I make sure that my motion, my memorandum of points of authority, my declaration, everything that I'm filing with the motion is bulletproof before I sign it. I do all my homework. I make sure there's no legal arguments the other way that would kind of put me into a gray area. I don't want to be filing motions and kind of not know what the other side's going to argue. Um, and when I did all my research, the other side really didn't have any arguments that held up from a legal standpoint. The only ones that the likely ones were, oh, well, you can't have legal custody because of the 3044. But that is not a sound legal argument because once again, orders have to explicitly be made. They can't be assumed.
Yeah.
And there was no order that terminated the joint legal custody. And there's a handful of case law to back this up here. We got in the remarriage of McGinnis that says custody orders must be made explicitly by the court, not assumed based on argument or implication. We have in the remarriage of Jensen, a vague or implied custody arrangement is not enforceable. The order must give clear guidance. We have in the remarriage of CT and RB, the appellate court reversed a custody ruling where the trial court failed to issue specific written findings regarding the 3044 presumption. If the court is using 3044 to justify a custody ruling, it must express findings in writing. That's very relevant to my case here. They can't just say the 3044 removes it and insinuate it. They have to specifically do their job and say, this party now has sole legal custody. And they never did that. And these are the type of arguments I made today. And despite all that, in fact, if I'm remembering properly, there was 2 motions combined today into one hearing. So I'm curious to get the court transcript. Sometimes you don't always remember everything perfectly, but if I'm not mistaken, I don't even think opposing counsel had to make an argument for this motion. The judge made it for them. And the judge argued with me about it the whole time, which is not the role of the judge.
To argue with you.
She argued, well, because of the 3044, you cannot have joint legal custody. And I gave all this case law. Not all of it. I gave some of these. And she said, I argued what these are saying, that orders cannot be implied. They have to actually be made. And if not, then the previous order, which was joint legal custody, still stands. And so she said, oh, well, I'm going to make the order then. Mom has sole legal custody. That's my order of clarification.
Wow, that would be a complete pause. That would be then, I guess, what well, shit. The objection that does have an objection to it. It's just kind of like how you can get the judge to shut up for a minute, that you actually get to give that objection.
Yeah.
And it's weird because you're objecting to the judge. That's like unheard of. You don't object to the judge is not
Maybe that needs to be a thing with how they're operating.
But I mean, so this is kind of one of those things like in court, the way procedures might go. Pro se litigants are going to be challenged with this all the time because it's like I've been challenged with this. I still am. Like when they are actually starting to, just say things that are like, okay, you just got it all wrong. But I'm not objecting to you. I don't feel that we're objecting to them. We're correcting them, and we want to be able to say it. But it's like the way that I feel like you get them to shut up for just that split second is objection. But it's like, but they will too. They will be quiet for that split second because they're
They want to find out what's going on.
Objection, right?
Yeah.
So get that in there maybe, and then be like, oh, but so I want you to see this is incorrect. But you're gonna have to use very strategic words, I guess, in that situation.
Yeah.
But man, dude, But like, I mean, this your scenario you're talking about, like how the judge just kind of like, they tried just going off on their own.
And maybe I'm not remembering that. Maybe opposing counsel did make a brief argument,
oh,
and the judge just latched on to that. So, like I said, I'm curious to get the reporter's transcript and kind of reread that.
oh
Um,
yeah, yeah. Well,
and this is a situation where, like, it's like you don't, at least for me, I have not wanted to rock the boat too much. You kind of try
yeah,
to ride that line where you want to stick up for your rights, but at the
yeah,
same time, you don't want to piss the judge off because of their egos. So
yeah,
today, she left me no choice, and I blatantly told her, "You're not following the law."
right,
She
right.
didn't. I don't think she really liked that.
I'm surprised she didn't
Um,
say like, the last time, uh, what did she say to you? Like you're a behavior or something? Because
oh no, that was a different judge at a
oh,
trial.
it's a different judge. Okay.
Yeah, early on I had to object and just put it on the record.
Yeah,
This is a violation of due process rights,
right, right, right.
and she got pretty upset and told me to stop talking, and then started
Yeah.
complaining about how late in the morning it was already, and because we had other hangups before we started the trial, which were clearly, they were not my fault,
Yeah,
and it seemed like she was just prejudiced the rest of the day. And then when she wrote the order,
yeah,
it said something along the lines of, I proved my aggression by talking over people and interrupting people all day long. And it's
yeah.
like, wait a minute, go sit in any trial with two attorneys and they don't at times talk over each other or
Yeah.
interrupt. And
Oh,
that's their
absolutely.
job. Now, of course,
Absolutely.
you kind of got to skate the line. You're not like yelling over people,
Right. You're
but you
not.
got to be a little assertive, or people are going to steamroll you.
Right, right, exactly. Yeah. I'm just gonna be if you're the quiet mouse in the corner, man, let me tell you that you're not ever gonna speak, right?
Yeah, just don't even show up and just let them do what they're going to do then, because that's exactly how it's going to play out.
Well, I wanted to give just an example of like kind of what you were talking about in the judge making this order and actually need to correct them because the same type of thing happened in one of my hearings. Um, God knows what's going on in these judges' minds. They don't read. It's almost like they just don't really read anything into your case, or if
I don't think
anything.
they do. I don't think they
It,
do.
yeah, and if they don't have knowledge of it, let the litigants speak about what has been, because it's
Yeah.
absurd. They're just now making assumptions. I had like my judge was was told by my ex that I was communicating with the school of my child. I'm sorry. What's wrong with that? Because that's usually never in a restraining order for
No.
the parent. Like you get a restraining order for a child, okay, sure, that might actually be something implied. But I mean, if the restraining order is for the parents, no, communication with a child's school is never a factor, and it's so weird and bizarre that my judge would actually try to state that I had no right to call and communicate with the school or make decisions. And I put her check. I was like, no, Your Honor, there was no check mark on any of this restraining order that restricted me from being able to go and communicate with the school. How is my daughter doing? And obviously there was like a whole lot of twist of like what my ex was trying to say in the first place. Oh, he's trying to like enroll her into some school or whatnot. And like, no, where's your proof with that? But yeah, same thing, man. Like the judge was trying to tell me you're not allowed to talk to, the school. I was like, no, because that's not what's in the restraining order, period.
Once again, an order cannot be implied. It's got to be made so people know about it. How can someone follow an order that was not written down
Well,
in the court ruling?
I got an even better one. Why are these orders not being very specific, very transparent?
That is
I
that's a consistent problem.
Yeah,
especially when it comes to some of the smaller things. And I saw this
yeah,
towards the end of the relationship with my ex when in regards to uh, her trying to, I'm not going to say co-parenting, whatever you want to call what they were doing with her son's father. Um, I think it was more about we'll call it controlling than co-parenting.
yeah.
But it seemed like if there was any vagueness to an order, she would interpret it however she wants,
Right.
however it benefited her.
However benefits them, yeah.
So, yeah, they
No
have to be
repercussions.
really careful. If they're going to involve themselves into these sensitive matters where you have people that are having conflict, then they have to really be diligent about not leaving gray language in there.
Oh,
It can
yeah,
be
good point.
interpreted or applied in different ways.
Good point.
You're
Good
dealing with
point.
two people that clearly,
High
or
conflict.
at least one person
Yeah,
who cannot get along and who's causing conflict.
yeah, yeah, yeah.
So you got to make the orders clear. I mean, that's common
Very
sense
clear.
too.
It's got to be so transparent. It's almost like here's a guide to turning on your TV when you buy a new one. I mean, it's got to be that clear.
And
It can,
this was what opened the door. The lack of clarity on orders is what opened the door
yeah,
for a restraining order extension to even be requested in my case.
yeah,
At the very beginning, when they first requested the first restraining order,
yeah,
and we started going into court proceedings,
yeah,
they immediately gave me 8 hours for about a month on every Sunday of parenting time until I got that 50-50.
yeah,
And they started putting in little orders in there, uh, contact or communication. You can communicate for this. You can communicate in this way. You can have contact, and peaceful contact for the purposes of coordinating visitation or exchanges, I think they said.
yeah,
Um, and then there were other orders. And so that's why I was doing the exchanges. Plus, they were at a police station. I don't know why they'd be in a police station if me, the supposed abuser, was not doing the exchanges. Then why would they have to happen at a police station? That doesn't make sense. And then there's other orders down the line where when you read them, it's very clear that at least that particular judge believed that I was the one doing the exchanges. But then we get through the 1 year restraining order and the other party gets a new attorney. She finds a little loophole of, oh, it didn't clearly say he could do the exchanges. I
yeah,
read it and I would interpret it as this insinuates, yes, I can.
yeah,
And so
yeah.
that's another example where they make these gray orders they're in this gray area, and
Don't
they're
you
right for
don't you
abuse.
love this one, Sam? Don't you love this one when they write on the order as agreed upon between the two? You're in a high conflict case with this person, and you're going to write in there as agreed upon between the two. How do you an agreed upon on a high conflict, type of actual co-parent, one obviously being the majority problem,
Yeah,
and that one is generally the one that's like, I want to control everything of the situation. I
yeah,
want control of everywhere that it goes. And that example, I was surprised you said to go to the police station. Back in 2020, and we were ordered to go and actually like have a person meet, or somebody exchange our child in a sense, right? So that would be like somebody to go and actually, take her from across the street over to me, kind of thing like that.
sure.
And when we didn't have that, and it was like, well, go meet me at the police station. I mean, where my ex is saying, I'm not going to the police station. I don't trust you going to the police station. What? But like, and then all of a sudden it's like, okay, so you're disagreeing to go. You're not going to agree to go. You're going to be kind of more of, this, I want control of everything. But when mentioning that crap to the court, to the judge and such, it didn't even matter. Like they didn't batter an eye at it. I mean, it wasn't like I presented it in such a way as like, well, she's completely not going to be co-parenting with me because she wouldn't even beat me at the police station. But to just say that, she wouldn't even want to meet at the police station for an exchange, the safest place you could possibly be when you think that you're dealing with some abuser.
Yeah,
I,
yeah,
hmm,
yeah. It doesn't make any sense. It truly doesn't.
yeah,
Um, yeah, and kind of an interesting part. I don't know if we spoke briefly earlier today. I don't think I told you this part. So I get home, and so I filed. I never got a response from opposing counsel. Usually someone files an RFO or a motion. The other party is going to file an FL 320 or some kind of responsive declaration,
yeah,
citing what they want, whether they agree or disagree with what's being requested in the motion, what their viewpoint is, what their legal arguments is, what their exhibits are, and so forth. And I didn't get anything, which is kind of the normal pattern. I At least with some of the recent motions. Really, this is recently. It's just been. I guess I should say it's just been more recently that I'm filing motions. I've always been kind of responding to these constant accusations, and
oh,
that's kind of what's got me where I'm at now. This is one of those things where you can't you can't just sit there and defend yourself the whole time and expect to win something, right? You got to have some kind of offense,
yeah.
um, especially when you've been attacked for 2 years with accusations. So, anyways, I get home
Hold
and
on. I just want to mention something. This could this could be I don't know if this has ever been done, but I just think this could be kind of funny. If they brought up some kind of accusation, right? And you just kind of like show up to court and be like, yeah, I don't know what the hell they're talking about. Um I've never heard of this before ever, but can I go?
well, I haven't tried it. I don't think it could work any worse than what's happened so far.
Right? Right? Oh my God.
Because you try to sit there and explain, look, this never happened, and what gets me is the pattern of accusations where they don't even provide details. They don't even provide a date of this. They'll say that he
Right.
murdered a puppy, for example, which clearly that's not the example. They'll say, oh, he murdered a puppy and
Yeah.
he did this and he ran over an old lady. But
Yeah.
not once did they say it happened on this date, at this time, at this location. All that's removed. Just, he did this. Just believe me. And that
Yeah.
seems to be what the court allows.
Yeah.
So, anyways, let me get back. I get home. Clearly I'm a little frustrated. I'm sitting here thinking, well, they didn't follow the law. I got to wait and see what her order is, I guess, because in January there was a motion and mom's attorney completely misled the judge and she made an oral ruling. And then 6 days later, I get the actual court order, the findings and order after hearing, and they completely backtracked because they looked at the case and realized, oh, I was right.
Yeah.
And so, I was thankful that they made a lawful, correct order. Um, So who knows? Maybe that's going to happen. I'm crossing my fingers, but I don't know. We'll see. But anyways, I get home. I'm home for. It took me. I had to do some other stuff at the courthouse, and I get home and I look outside on the front porch and saw mail. So I went out and grabbed it. It was a big yellow Manila envelope,
Yeah.
and it's from the opposing counsel's firm there. So I open it. What do you think it was?
Got
A
that.
declarative response for the two motions today. So and I checked the ring camera. It didn't show up until I think it was almost 2 hours after the hearing took place. It showed up. And so I opened it and I start reading through it, and there's really no legal arguments in it, and that's been a clear pattern. Opposing counsel does not argue, and I think it's because they know they're not correct. They're not coming from a legal perspective because, in my opinion, they're in the wrong. So their strategy has been to make accusations and frame things in an emotional way to try to get an emotional reaction or emotional ruling from the judge.
Right.
So it
Right.
was littered with accusations of I'm violating the restraining order.
Yeah.
Um,
That's
Currently, there's restrictions for the exchange on Saturdays that I'm not allowed to get out of the vehicle. I have to have a third party there to facilitate the get out of the vehicle and help my daughter walk across the parking lot and so forth. She said multiple times that I violated that. And what's interesting, I don't know if these accusations are coming from the other party or the attorney. They said that the whole reason that that restriction is in place on Saturdays is because the lobby is closed to the police station. So, mom convinced a judge at one point that, well, because the lobby's closed and I'm such a dangerous person, he needs to stay in the car. And so that's why that part is in there. And so she says makes this accusation that I violated the order multiple times on Saturdays by getting out of the vehicle and then even said I went inside the police station. Wait a minute. The lobby's closed on Saturday. That's been your argument for why I have to stay in the car. And now you're saying not only did I get out of the car, but now the police station lobby is open on Saturdays?
yeah.
And so it's littered with all kinds of things that don't make sense. But
Oh,
what's interesting is as I read it, it seems to line up with the position that the judge was taking of, well, there's a restraining order. You can't have joint legal custody. The 3044 is in place. You can't have joint legal custody. But there's plenty of case law that contradicts that belief because there was never an order that explicitly changed the legal custody. And
uh,
what's even so not only did I physically get this responsive declaration after the hearing, which would be an untimely service, but even the date on the proof of service said that it was mailed out on the 3rd, which was 6 calendar days before our hearing.
yeah.
A
Well,
responsive declaration has to be served 9 court days before. So even if they physically handed it to me, the date that they put on that proof of service,
it's still not valid.
it's still late.
Yeah. That actually was something we probably should do even an episode on, because these whole sleazy tricks that these attorneys try to pull in court are just despicable, man. Like
It
when
is.
they try to drain out the time that you have in a hearing as a way of actually avoiding or just well, I don't know, avoiding, but also like just trying to take away from your ability to give a testimony or give statements, to provide any kind of evidence, there's that strategy. And this is something I've definitely experienced with, of like, man, just trying to get your case railroaded because you had no time to even try to present, and based off, like, you're dealing with that attorney. Nonsense, yap, 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 just
And the problem is
crap
it's
quotes.
the problem is it's very clear these judges based on their behavior, it's very clear that they just make these assumptions that, well, you're a pro per or pro se litigant
Yeah,
and this party has an attorney.
yeah,
If they're saying something that contradicts what you're saying, I'm going to side with them. It's
yeah,
like they act like they have some kind of moral superiority that they're not going to lie, that
yeah.
attorneys are not snakes in the grass, like attorneys have some kind of awesome reputation. I mean, I don't
Dude,
think that's
that's
what the majority of the public thinks of attorneys, right?
90%
um,
of attorneys right there. I'm going to say, declaring it. 90% of attorneys in my book, they all like to feed this this BS narrative, and they're not honest. They're all
no,
trying to paint this ugly
it's
picture of the other.
and maybe they went to law school with good intentions, some of
Maybe,
them, but I don't know if it's just the money takes over, the ego takes over.
right.
I don't know what it is, but they're there. They're not there for the kid. They're not. They don't have any best interest of the standard clause that they need to, follow.
Yeah.
They're
Well,
there to win for their client, but they're there to also not rock the boat with the judge.
right,
You know?
right.
And And so it's like it's like these judges have this mentality that, well, you're the attorney. If we're talking something legal, you're going to know what you're talking about.
Yeah.
But it just depends who they're arguing for.
Yeah.
So for them to act like the attorney is going to be the one that's correct when making a legal argument, it's insane. Because if they were arguing for me, they'd be arguing something way different. It just depends whose side they're on. The attorney, right?
Whose side they're on. Yeah. Yeah.
We could take that same attorney from today and put her on my side, and it would have been way different.
Yeah. Yeah. Yeah.
Her arguments would have been way different. The ruling would have been way different, I think. Um,
I can't say that. I can't say that, like, of all the attorneys I've had, I'm trying to think of like where they painted an untruthful picture. Because everything that you could say about my ex was true, though. And that's the thing. That's the thing. It's like like they're like the last attorney, I don't know, last year, who actually like started like, we believe there's parental alienation going on. Yes, there actually was, and it was being recorded and such. And it was like, I don't know if he thought he was painting the picture, but it was like, it's true. Like, I don't know, some of these clients, maybe even like they get an attorney, and then they just start painting their own, imaginary world, and an attorney just has to go with what they say. There's that too, I guess. I don't know if that could be possible, but I also see, like, if you're going to believe this, question it, maybe, question it. Otherwise, it's like
that's an excellent point right there. Not, I don't see a lot of judges question. I don't see them watching there
yeah,
and critically thinking and analyzing the situation. I
yeah,
see them watching, but it seems like they very quickly hop to one side. The only judge I've ever seen sit back looking like he was trying to truly be objective
yeah.
and analyze and question things was the judge that gave me 50-50 parenting time while waiting for the trial.
I can't
And
believe that shit, man, because I never. And like, was this something that was actually presented to the judge, or the judge just randomly came out and asked you, like, yeah, what would you like for parenting time?
so this was the second follow up for the restraining order. We had one follow up in the middle of December of 22. Mom didn't have all her evidence, had a bunch of excuses, had family members that wanted to testify, but they couldn't come for work. And so they set another hearing. So we come back like 3 or 4 weeks later. This was that hearing. Um, I was initially supposed to be heard by a commissioner. My attorney at the time said, this guy's kind of a wild card. He's kind of dangerous. So I think we should object. She said, it's up to you, but you might want to consider objecting to be heard by a commissioner, and they'll find a judge for us to be heard by. So that's what we did. And they said, okay, we'll come back and come back after lunch at 1:30. So we had to come back a few hours later. And younger Hispanic guy, slick back hair, very clean cut looking. And I was listening to the case in front of me, and I already just had a good feeling because I was watching how he was conducting himself. He was asking questions. He seemed like he didn't feel like he was on anyone's side. He was
Mhm.
asking questions of both sides, being very critical of both sides. And so for me, that was a good sign. And when we started the hearing, once again, mom didn't have all her evidence. And so the judge got on it pretty fast and started questioning her and grilling her. And she was falling apart. She didn't have an attorney at this time. He was, really putting the pressure on her as far as, why don't you have evidence here? This is almost 2 months later since you filed for a restraining order. And
But I'm
so, yeah,
wondering,
my attorney did make the arguments, though, that this is all being done to impede in custody. And they did request that the standard, if it wasn't for this restraining order, the TRO, the standard would be 50-50 custody.
well, wait,
Yeah.
I want to back up because of my question was, did you request to have any type of parenting time during this TRO, or did the judge come out and ask you this? That's what I'm wondering.
The judge did not ask us what parenting time we wanted. My
Okay, so
attorney
you
at the
guys did.
time, my attorney at the time argued this is all being done to impede it. We're 10 days away from final custody orders. And so my attorney argued this is all being done to gain leverage when it comes to custody and to prevent fair custody orders from being made. And being that the judge was clearly questioning her on the fact that she had no evidence after 2 months and just had nothing but excuses, he granted he did give her her trial she was requesting, but at the same time issued 50-50 parenting time until that trial.
So wait, I don't get it. So you're saying that he didn't ask anybody. He didn't ask anybody of like what kind of parenting time you wanted at all. He just came up with it on his own.
No, well, my attorney argued that if it wasn't for this TRO, the default would be 50-50. And then she argued that the whole point of this restraining order is to affect custody. And clearly, 2 months in, there's still no evidence of anything. So that's when he made the call to order 50-50 parenting time, while at the same time giving her the trial, which I wish that would have never happened because I'd be in a completely different situation.
I'm just really confused on this right now because so you guys did not specifically ask the judge to make this a 50-50 parenting time, and
I would imagine this is years ago at this point. This was
this is during a
the
TRO.
beginning of the January of 23. So yeah, this is over 2 years ago. I would imagine she did specifically request an increase to 50-50 parenting time. Yes.
Wait a minute, she requests. I thought you didn't have any.
My attorney was a she.
Oh, sorry. Okay.
Yeah.
Okay, yeah. I was like, wait a minute. Now I'm really lost. Yeah, okay. Well, I'm just learning. I'm just saying this because I learned from 2020 that apparently I didn't learn it then. Sorry. I wish I would have learned it then. But I learned that anybody who gets caught in this trap of the TRO can request for, I want parenting time. I don't care what that is, whether that looks like supervised visits, whether that looks like maybe I sit it for 4 hours unsupervised, or have somebody who's a friend of the family, be there. But the fact is that I just can't believe that this is like something that's like you have to learn to actually be able to ask for such a thing, because it's just assumed all of a sudden you get you're taken away, you can't see your child.
Well, I
What
think that's
you
because
would
they
never
issue
think
these.
that they could ask that question.
Well, I think it's because they issue these TROs or these restraining orders a lot of the time through ex partes, and they immediately, a lot of the time, they put the child on the protective order,
Yeah.
and they immediately remove all custody. I didn't see my daughter for over a month.
Well, but this is the point though. I'm learning that you actually have the right to request some kind of supervised visits or
Yeah,
some
yeah,
kind
yeah.
of
They're not
visit.
going to just say, "Hey, I think the child might be missing dad. I'm going to give dad some time here." Like you got to go in there and say, "No, this is what I want. This is what would be best for the child. These are my arguments."
Right, right.
You
And
can
that's
have
the
you.
problem. It's
A
like
closed mouth doesn't get fed.
that's the problem is like you gotta this is one of those stupid little things you have to learn like the hard way. I don't know anyone else out there. I've never seen one podcast that ever said, parents, make sure you go and ask to have your supervised visits or some kind of visitation with your child. Have some kind of parenting time because that's like you are owed that, even though it's a freaking TRO. And it's so
And
it's
here's the deal with those TROs. There's no 30-44 presumption
yes, right,
that makes it to where you can't have joint legal custody, you
right,
can't have
right,
joint physical custody.
right, right.
There's nothing that specifically requires them to remove parenting time from you. They use their discretion.
Yeah.
which we talked
Well,
about is often abused.
you
And
learn
they
it, you learn
love they
it.
love hiding behind this phrase
Yeah.
best interest of the child. And that's one of
Yeah.
these
Yeah.
very vague statements that is seems to be open to their interpretation only.
Yeah, only their interpretation. Exactly. Yeah. It's
And
like
they decide without ever meeting a child or even seeing a darn picture of these childs.
right, right. Yeah. They act as if they're the professionals of, they know nothing about children. Hell, you'll
Yeah,
even see these judges that don't even have kids. And it's like, oh, you're supposed to
potentially. Yeah,
you're the one that's supposed to make the decisions about my child? Are you kidding me? What are you,
yeah,
a psychopath? Oh yeah, you are. I forgot. But the whole learning process. So getting into 2022, when I was actually then getting this another TRO issued against me, and it's going months on down the road. Like I'm not getting to see my child at all. What the hell's going on here? And the whole time, I never even went to go ask the judge. Look, ask the judge, tell the judge, I need to have time with my child, as you have got nothing against me that actually shows that I'm a threat to my child.
yeah. And this was this during the TRO when you were waiting for trial?
Well, see, that's the thing. My situation is so effed up, man. There was never a trial issued to begin with.
They
Like,
issued a 5-year restraining order off of fear at a 15-minute hearing.
no, it was multiple hearings of
Huh.
20 minutes, 20 minutes, 20 minutes, then getting into there actually was an evidentiary that was then uh motioned for, but it was like in the hearing, like, okay,
Yeah.
we're gonna need to have a half a day, to come in and talk about this, and then once we got a full day in there. Okay, we're going to continue this to another. But the whole time, I was never told, like, we're going in as a trial. No,
Yeah.
it's really absurd that they did it this way, especially when I told you about the two different cases that were actually two different case numbers, but then they were actually eventually they said they're going to hear them as related cases.
Sure.
And I mean, you want to talk about a clusterfuck, man. That's a clusterfuck when you're a proper litigant, because you're like, I don't get it. We got two cases, like both of them have to be heard at separate times, is the way anyone would think. They
Sure.
tried hearing them literally like at the same time, but focused on my ex's case, not my child's case, my ex's case.
Yeah.
Which was like, okay, they knew that no matter what, the judge was never going to, either the attorney knew the judge was never going to issue a restraining order for my daughter, because especially there was nothing there. There was
Yeah.
nothing at all there. And she just then thought, okay, these judges are always going to give a restraining order to a woman, in these type of situation. Um, Either that, or just, the fact is, hey, you got two cases here, and the judge just really didn't really care how the attorney was gonna to go into this. I'm not
Yeah.
sure what his motive was. Maybe he wanted the restraining order for her no matter what. He knew he couldn't give me one for my child. You know,
Sometimes, man, it really feels like they have a motive. And I know I've mentioned to you, I think on this podcast, that the trial judge for this restraining order extension,
yeah,
I don't think there's anything I could have said or done differently to affect the outcome.
right,
I don't
right,
think there's anything I could have done differently leading up to the trial that would
right.
have affected the outcome. Just getting her and having opposing counsel say what they said,
Yeah.
that was enough for her. They didn't need evidence, they didn't need dates, times, anything. Just people willing to say things. Preponderance of testimony, that's what they use in these courts.
Preponderance. Oh, the preponderance. We're gonna have a whole nother one on that one too.
Yeah.
Uh wow. Uh the preponderance of evidence and all that. Yeah. Well, I don't know about you, but I kind of want to say that this has been very informative, and I think we share some good quality story and tips and whatnot.
Yeah, yeah, for sure.
Yeah, we'll try to get some case law and such that we can share. Uh, maybe even check that out in the comments below and such. But yeah, thank you very much for sharing all of that with us today, Sam, and thank you everybody for who's getting a chance to watch and learn a little bit. But Sam, I think I lost your video, my friend. Well, while Sam's fixing his stuff, just gonna say, join us every week. We are gonna be having more and more of this for you. And hey, share some of your experiences with us in the comments.